Hello, Namaskar. Today we are going to discuss about a course, uh, Certificate in Social Work and Criminal Justice System. Within that, I am going to deliberate on a specific topic which is part of the course MSW 032 and the name of the topic is Principles of Criminal Jurisprudence. So, first of all, I wish to introduce the topic. Why do we need to understand the criminal jurisprudence? If you see, for any sorts of law, there are certain philosophy behind creating that in law or the legal principles. So that philosophy behind that law is part and parcel of the jurisprudence. And when we talk about criminal law, there are certain philosophies and reasoning behind creating certain principles and certain enactment in form of a statutory enactment. These are created on the basis of certain reasoning, and that reasoning forms part and parcel of the jurisprudence. So when we talk about criminal jurisprudence, it is branch of the criminal law which forms act, that means a statutory act, punishment, processes, and also investigation, prosecution, adjudication under the different sets of offences. So what I was trying to say that jurisprudence encompasses various sets of legal components which are part and parcel of a statutory act, processes, investigations by the police, as well as adjudication in the judiciary. And when we talk about criminal jurisprudence, it talks about certain principles, as I enunciated earlier, that these are based on certain principles which we are going to deliberate today. And there are certain rules which has to be followed in the criminal justice system. And the procedure are important because if we are violating procedure, it will not be able to provide fairness and accessibility of justice in the criminal justice system. So it is very important that we follow certain processes which are uniform for all, and in all cases same processes are prescribed, barring few instances where there are certain, you can say, exceptions are there. But we follow some uniformity so that we can provide a sense of justice to the litigant. So there are some key aspects of the criminal jurisprudence which constitutes, as I told you, a statutory enactments in the form of different sets of act which are related to criminal law. And the recent enactment in 2023 is the Bharatiya Nyaya Sanhita 2023, which is replacing the old criminal law, which was Indian Penal Code 1860, very old law which has been replaced. The second part of component of the criminal jurisprudence is the punishment. As you know that punishment is part and parcel of the criminal law. And another part which I was discussing is the procedure. So there are certain criminal procedure which has to be followed in adjudication of the cases, and in that case new enactment has come up, and that enactment is known as Bharatiya Nagrik Suraksha Sanhita. It is coming along with Bharatiya Nyaya Sanhita 2023. Three sets of act that has been enacted by the central government, and all this is the basic motto of this session was to introduce the new changes as well as to highlight the fundamental or foundational principles of criminal justice system on which our system is based. The fourth one is right of the accused. As you know that there are when any person is a criminal offender, so he has to go through certain processes. Police will investigate, they will do the inquiry, and they will do their own work. In that processes, there are certain rights which are part and parcel of the constitution, which has been given to the accused. 20, 21 and 22, all these are the article where there are certain rights which has been enshrined in the constitutions related to the rights of the accused. And there are certain rights which victims enjoy. That means in many cases you will find that victims have right to privacy. In rape cases there are right to privacy for the victims are there. So there are certain rights which are victim also getting. So all these are part and parcel of criminal jurisprudence. When I was telling that why when we talk about criminal jurisprudence, we need to know about reasoning of all these rights and entitlements of the accused or maybe the victims. And the last one is rehabilitation and reintegration. So criminal justice system is based on the principle that finally the accused have to reintegrate in the society. That means they have to go to the mainstream in the society. And the basic motto of keeping them in jail or in incarceration is not to just to punish them. The motto is also to make them make them a human and you can say responsible citizen of the country. And in these processes, what we are doing is that we are trying to prepare them so that when they are out of the jail, they will go and they will do the normal things and they will contribute in the nation building process. That is the process of reintegration, which is the last part of the judicial process. So why do we need to understand criminal jurisprudence and what are the benefits of understanding criminal jurisprudence? So from the social work point of view, there are some points which I have highlighted, which is protection of rights. So if you know the principles and rules of criminal jurisprudence, you will be able to defend yourself or protect the marginalized community, which is part and parcel of the intervention in the social work settings. So there are certain rights, like right to remain silent. Many of us are not knowing that even if police personnel are asking, we have certain rights that we can keep silent on certain matters. Right to legal representation. That means every accused has right to represent himself or herself in the court of law through lawyer. Protection against unlawful searches and seizures. As you know that there are many times police are doing excesses and they are doing illegal searches. In that case also there are certain rights. If you know the fundamental principles of criminal jurisprudence, you will be able to protect rights of the client or you will be able to protect the rights of the marginalized community. So another point which comes into light is the compliance and avoidance of criminal conduct. So if you know the law and if you know the reasoning behind that particular law, you will not err. That means you will not be committing crime again and again because you know that something is prohibited and something is not to be done. Fairness in the justice system. So if you understanding criminal procedures and principles contributes to ensuring fairness in the system. That means if you know the system, you will be able to better access the system and it will generate fairness in the system. Protection of the society. If you know the criminal principle, it empowers citizens through knowledge and through information. They empower themselves and they create certain, you can say they create such an environment that nobody is fleeced into different sets of criminal activity. So it is also a protection or ensuring protection of the communities. Prevention of miscarriages of justice. If you know law in a proper way, or if you are able to enunciate certain principles which are involved in the criminal jurisprudence, you will be able to prevent yourself from wrongful accusation. Many times people are implicated in the cases where they are not present and they are not present as well as they are not involved in that particular cases. In that cases, you will be able to protect yourself from these excesses. So how this process during the passage of time, how it has evolved. That means how criminal justice system as well as criminal jurisprudence has evolved by the passage of time. If you see this the ancient system. So ancient system was based on different sets of philosophy that is based on the religious philosophies like Hindu, Buddhist, Jain. All these are and Sikhs. All these are part and parcel of the indigenous legal system where certain principles are emerging and forming in the and crystallizing in the form of law. And the sources are Vedas, Upanishad, Dharma Shastras, and Arthashastra. And if you move little later, you will find that Emperor Ashoka in the Mauryan Empire witnessed establishment of a centralized legal system which was based on the principle of Dhamma. So all these are you can say remnants of what we can see as a criminal justice system today. If you little move in the later period of time in the medieval India, you will find that there was advent of foreigners, and they came with a different religion, and later on Islamic legal traditions were implemented in India during the Sultanate and the Mughal rule. And later in 17th century, after advent of the colonial powers, Britishers occupied most of the country, and they established a separate legal system, and which was quite new to the Indian legal system, which was based on the common law legal system. So common law, what is common law? Just to explain that in that time, Britain was having a lot of colonies across the globe. So they were enacting law in the England, and all those laws were applicable in different colonies where they were ruling. As these laws were common for all the colonies, that's why they called these laws as a common law system, because system was same for the country to country. Due to cultural variance, there was some modification in the law, but system was same. That's why this system is called as a common law system, which was still even today we are following the common law system, because our structure, the structure of the court, structure of the judiciary, and structure of the police station, and all processes are part and parcel of the common law system. And post independence, you will find that there is a gradual development, and where there is a mix of custom as well as there is a mix of Western colonial law, which is coming and which is still evolving. So the Bharatiya Nyaya Sanhita is part and parcel of that particular system. So if you see the evolution of legal system in thousands of years, it has been influenced by various factors, and to date whatever we are seeing, it is coming out of these influences which has caused in last 1,000 years. So let us discuss about different sources of criminal law. So the Constitution, being the mother law, is the source of any other law in the country. So even in the Constitution, there are certain provisions which are directly related to the criminal law. So if you see Article 21, which is talking about right to life and liberty, and prohibition of against double jeopardy, Article 20, and Article 22 is the presumption of innocence. So these three articles forms core of the criminal justice system within the constitutional framework. So right to life and liberty is very clear. So let it be like that. Let me explain prohibition against double jeopardy. It is the principle which is saying that no person can be punished for a single crime twice. That means a person can be punished for a single crime only once. For the same crime, he cannot be convicted for twice. And the presumption of innocence is the principle which is based on the Article 22 of the Indian Constitution, which I am going to deliberate in the later section of this session. The statutory law. So statutory laws are basically part and parcel of the enactment of by the legislature. The law which are enacted by the parliament or state assemblies are statutory law. So Bharatiya Nyaya Sanhita, Bharatiya Nagrik Suraksha Sanhita, Bharatiya Sakshya Act 2023 are part and parcel of statutory act. Earlier these were the older law, as I already discussed. Indian penal system 1860 was the law, substantive law for dealing of criminal offences in India. And there are certain laws which are part and parcel of a statutory law and related to the crime, Unlawful Activity Activities Act, Prevention of Corruption Act, NDPS Act, Juvenile Justice Act. All these are related to the crime. So that's why and all these forms the part of the statutory law. Precedents and the case law. So this is a different category where Supreme Court and High Court of India are the court of record. So whatever they are deciding, these are part of the record, and these forms precedents for the subsequent cases. Like whatever has been decided by the Supreme Court today, later on it can be based for certain cases, and on that basis someone can get relief. So this is the precedent and case law, which is also part and parcel of the sources of criminal law. And another one is customary law. Custom and tradition law has to be culturally a sensitive, you can say. Otherwise, following law will be very difficult. So local customs and traditions has huge influences on the legal enactment. That's why customary law also forms part and parcel of the sources of criminal law. Now let us discuss the foundational principles on which criminal law is based. The first foundational principle is presumption of innocence. That means even our Constitution, Article 21, talks about the presumption of innocence in terms of protecting life and liberty of a citizen, every citizen. So when we talk about presumption of innocence, we intend to convey that whenever anyone is accused of any crime, the fundamental presumption will be that he is innocent till proven guilty beyond doubt. So if a person is accused of a certain crime, he will be treated as innocent till he is proven guilty beyond doubt. So the investigation process, dealing of the cases by the police as well as judiciary, it starts with presumption of innocence, and on that basis only investigation as well as adjudication will follow. And Indian Evidence Act and subsequent enactment of Bharatiya Sakshya Act, the burden of proof lies on the prosecution. So there are two parties. There are two parties in the cases. One is prosecution, one is defendant, and in that cases, prosecution has a role to prove the guilt of the accused beyond doubt. Then only, in that cases only, he will be punished. And apart from Indian Evidence Act, even Supreme Courts and High Courts of different states in India has enunciated regarding innocence, presumption of innocence as a foundational principle in the criminal justice system in India. The second part is burden of proof. And the principle of burden of proof is a fundamental aspect in fair trials, as it enshrined in the various legal provisions in the Indian legal system. So general rule regarding burden of proof is that burden of proof lies on the party who asserts the affirmative of the issue and not on the party who denies it. For example, someone is alleging me that I have done theft, I have stolen some property. He has to prove that I have stolen the property. I don't have to prove that I have not stolen the property. So beyond reasonable doubt, he has to prove. So in that case, burden of proof lies on the prosecution. Those who are alleging the act, they have to prove beyond reasonable doubt that this act has been done by this person. The second point which comes at 4 is a standard of proof. So a standard of proof is important to understand from the point of view that that only in case of the proof beyond reasonable doubt, in criminal cases, accused can be punished. The prosecution must prove the guilt of the accused beyond reasonable doubt. And this high standard of proof has to be followed in every case. Merely creating doubt will not suffice when it comes to punishment. And the second point in the burden of proof is related to right of the accused. So accused is not required to prove the innocence. As I told you that if I have stolen the property, I don't have to prove the innocence. The party who is alleging that I have stolen the property, he has to prove that I have stolen the property. I will deny in any case. And I will provide the points and the defense argument that I have not done that. This is a part of the right of the accused. If you move little ahead, there are certain principles which are very important when it comes to understand the criminal jurisprudence. And one such principle is mens rea. So mens rea is a Latin word which is used very commonly in the criminal law, which refers to the mental state of the criminal or intention behind commission of a certain crime. So it literally translates from Latin. If you translate it in English, it comes like a guilty mind. So why this is important? Let us try to understand that any act that has been done without intention, that means I don't intend to harm you, but due to my action, that means due to my voluntary action or due to my accidental action, the harm has been caused to you, but intention was not there. So in that cases, what happens is that court will assess that whether guilty mind was present at that particular time or not. The second point which comes into the and the second point is knowledge. Apart from intention, the second is knowledge. Like if you see, a child is not able to understand that if I am shooting the pistol, it can kill anybody. So if a child of a mere 5 years or 7 years of age, due to accident, if he is shooting through pistol and someone is killed, so in that particular cases, he is not able to foresee or he is not having knowledge regarding the implication of that particular action. So intention was not there in that particular case. The second point is requirement of conviction. So mens rea is important component when it comes to you can say conviction. Without intention, involving intention, it is not possible to convict a person. And also there are a degree of mens rea. That means, as I was referring to, that in many cases we are negligently doing the act and we are harming someone else, and involuntarily doing the act and harming someone else. So if we have a clear-cut intention to harm anybody, and if I am doing these activities which are harming anyone without any intention, the sentence, that means quantum of sentence, will vary from in these two cases. And defenses based on mens rea. In certain cases, you will find that due to absence of mens rea, people are acquitted in that particular case. So mens rea, so far I have discussed these foundational principles, and after that once is actus reus, which is very important, that apart from mens rea, action has to be there in the form of crime. If action is there, intention is there, then only if these two are meeting together, then only a person can be convicted for a crime if investigation is suggesting in that direction. With this, I will stop here. Thank you.